everybody, and welcome to the Aspen Author webinar series. Today's topic is corporal criminal investigations and prosecutions. But before we begin, I have a few housekeeping items to review. First off, the audio for this webcast is through your internet only, so I do recommend using a headset, earbuds, or listening to this presentation through your laptop or mobile speakers. Secondly, this is a one-way communication channel. You can hear us, but we can't hear you. So if you have any questions or want to join in the conversation, please use the chat feature to your right. And now I'll hand it over to Justin to introduce today's presenters.
Thanks, Ali. I won't take up too much of your time today, folks, but I did just want to say, as the managing editor for White Collar Crime books at Aspen, it's been a great privilege to work with Leo, Dan, and Eugene on this book. I think they bring a really refreshing and interesting take to the teaching of white collar crime. And, I won't take up too much more time here. I'll turn it over to them. Leo Sau, Dan Kahn, and Eugene Soltz. Thank you very much for doing this today.
Thank you. So Eugene, do you want to get started, and we can?
Well, first, maybe shall we introduce, and Leo being the first author of the book, maybe Leo, you want to start us off with a bit about you, and then Dan, and then I'll do a short, and then I can put some questions for us to consider.
Sure. Yeah. Thanks everybody for taking the time today to join us. We are super excited to talk to you about corporate criminal investigations and prosecutions. I have been working in this area for a number of years. I spent 17 years in the DOJ, the last 10 of which at Main Justice in the fraud section and the money laundering and asset recovery section, where I worked a lot on corporate criminal cases and FCPA and Bank Secrecy Act and sanctions violations. I've also spent a number of years at various law firms. Right now, I'm a partner at Paul Hastings, where I'm working the investigations of white collar defense group, as well as the fintech and payments group. I've taught at several law schools over the years, Temple Law School. I currently teach at Georgetown Law School, and I currently teach at Harvard Law School with Dan Kahn, a course on corporate criminal investigations and prosecutions, and look forward to talking to you all today about this subject.
Great. Thanks, Leo. My name is Dan Kahn, and like Leo, I spent time both in a law firm as well as at the Department of Justice, and spent a little over 11 years at the department working mainly in the DOJ's criminal fraud section. And there I was the head of the FCPA unit, Foreign Corrupt Practices Act, and then head of the fraud section, which oversees FCPA, as well as financial fraud, wire fraud, securities fraud, commodities fraud, as well as healthcare fraud. And then most recently was the acting deputy assistant attorney general over the fraud section and the criminal appellate section before returning to Davis Polk and Wardwell, where I'm a partner in the DC office working on white collar defense and investigations.
Great. Thanks, Dan. And I'm Eugene Soltis. I'm a professor at Harvard Business School, and my work focuses on primarily using data science to better understand corporate compliance programs and how to prevent, identify, and respond to various white collar issues. I'm particularly, I think, privileged to be here with Dan and Leo, and I thought maybe to help motivate our discussion today about how this book came into fruition in the first place. A number of years ago, I think I was at the fraud section presenting, and it led to some great conversations with Dan and Leo, who he's very close with. And we were describing how the desire to potentially teach a class we started at Harvard Law School a number of years ago. And the class in the original that we put together had a lot of memos, a lot of pieces that we were taking the original documents, which was just provided to students in the class. And we realized that there wasn't actually a great way of bringing together all those pieces of information. They're on the websites of the DOJ. A lot of it's known from people both in the defense and on prosecutors. Some of it's known in-house, people that are doing compliance and investigations, but there wasn't actually any comprehensive place that put it all together. And so to give Leo credit, Leo said we should be writing a book on this topic. And then a couple of years later, we were thrilled to have this put together. But I think there is I'll play the professor role here, but maybe to help spur an interview, the two, I think, by all accounts, the absolute leaders, the best people that one could imagine to help us better understand the space are Leo and Dan. And so maybe for background to kind of set up about why this area is interesting and significant. I mean, this is an area that draws a lot of attention from students and practitioners because it's been a significant and growing area if we think of the broader legal space. And this is not due because there has actually been a lot of changes in the actual underlying law, but rather the changes in how that law is enforced and what the processes are around that. And it's not particularly, I'll say, broadly well understood, in part because there aren't a lot of, and for reasons we'll go into, trials or the degrees of transparency that sometimes people normally expect to see. And there are good reasons for why that actually occurs. But maybe if I turn to Leo and Dan, I'll put up with a warm call here. But you've seen the last 20 years. I mean, if we go back for 25 years ago, prior to everyone worrying about Y2K in 2000, there weren't a lot of cases in corporate criminal. I don't think this book would actually exist in many ways if we were to go back to 90. There are certain specific areas, but if we think of Foreign Corrupt Practices Act and other areas, there weren't a tremendous amount of cases. So what happened between the mid 90s and where we sit today that makes it such a significant and important area of the law?
Yeah, I'll go first. I think a couple of things have happened, Eugene. Number one, I think that there's been more of a focus on corporate misconduct. I think that there's been more, with the financial meltdown, for example, a lot of episodes over the years, the BP oil spill, where I think there's been a lot of demand from the public to hold corporations accountable for what they perceive to be corporate crimes in nature, in addition to executives and employees who have carried out these crimes. And so I think what you've seen over the years is an increasing number of big corporate resolutions, including headline cases. You read about these corporate cases a lot. And so, over the years, the Department of Justice has instituted some policies to try to keep up with the rise in corporate prosecutions. But I think that as prosecutors continue to see that you really can have an impact charging individuals, but also charging corporations to change the behavior at the corporations, change compliance policies, change incentives to try to really, turn to encourage companies to be good corporate citizens. I think this is something that is evolving, and I think that's what we've seen over the past 20 or so years. But Dan, I'm sure.
No, I mean, totally agree, and I think a big part of it was the reaction to what was happening with various financial meltdowns, as Leo described it, but also Enron and WorldCom and the issues sort of in the late 1990s, early 2000s. But I think, and I don't think this can be overemphasized. I think the fact that there are alternative mechanisms to reach resolutions here, the deferred prosecution agreement, the non-prosecution agreement, really allows the government to not necessarily step on the gas all the way and say we're indicting or the company's going to be taking a conviction, which may have all sorts of collateral, particularly for certain industries, or simply walk away. The fact that you have these alternative mechanisms, I think, has led to a lot more negotiated resolutions, and I think because of that, you've now seen really across the globe a number of countries looking to mimic the U.S. system, or at least in some way create a similar structure. And so in the UK, in France, Australia, Canada, you are starting to see all of these systems create a deferred prosecution agreement, which allows them then to really focus in on what Leo was describing, which is the incentives to try to get corporations to cooperate, to voluntarily disclose, to bring misconduct to the department's attention, and frankly make the department's job easier and quicker in order to bring these types of cases.
And when we say charging companies, because I think we all know from literally elementary school what it means to charge an individual criminally. They go to a courthouse, there's a jury, people could go to jail. But this book is actually about corporate criminal, critical word being corporate or organizational. So maybe what does that mean? Because I think that concept itself is quite foreign to, I think, many people that observe that it's not individuals here, and individuals are an important part of the story, but the book and actually much of its innovation is around this focus on the organization.
Yeah, so I think it's the most fascinating question that it underlies the entire book. The class that we teach, we spend an entire class and it on this question of why should we charge corporations? What does it mean to charge a corporation? What does it mean for a corporation to act or a corporation to have a mental state? Because it really is not it's not an easy question to answer, and there's a lot of disagreement in the academic circles and frankly in the judicial circles as well about what does it mean to charge a corporation for corporate acts. And the law has come up with a proxy, respondeat superior, which says that so long as one agent or employee of the company is acting in furtherance, within the scope of their authority and at least in part to benefit the corporation, the courts have just said, simple, easy rule. If that happens, the corporation is liable. But it's unsatisfactory to a lot of people because it's a short and simple rule, but it doesn't quite capture the true conduct of the corporation, and it ignores, for example, the corporation's compliance policies or efforts to try to prevent crime. It ignores what executives may have done or who is involved in the crime. And so, this question about charging a corporation, I think is the most fascinating question, and that again it underlies all these policies, a lot of these discussions in terms of teaching this subject. And so every year we get different views and a lot of lively debate about whether or not corporate criminal liability is even appropriate.
Right.
Well, even though it is here.
Right. And I mean, just to emphasize the point, Eugene, that you made in the question, it's not as though you can handcuff a corporation to the flagpole outside their front door, and so it's not as though you're sending them to jail. And so the question really is, what is the difference between a civil resolution and a criminal one? Is it just reputational? Is it just the retributive factor? And so there are a number of parts of the book that really delve into, I think, what you can achieve through criminal prosecutions and resolutions with corporations as opposed to civil, both from an investigative standpoint as well as from a remedy and remedial standpoint. So I think it's a great question, and it's one that I think a lot of jurisdictions, again, if you look across the globe, you see a lot of jurisdictions handling this question differently. Some have corporate criminal liability, some don't, and it's interesting to see the dynamic and the juxtaposition between and among those countries.
Mm-hmm. Well, talking a little bit about kind of the international, because on one hand, the book's talking about U.S. law and how the U.S. engages in corporate criminal liability. But if we look at many of the larger headlines, during both of your tenure at the DOJ, many of the more significant cases are not U.S. companies. They're companies headquartered elsewhere. Maybe it'd be great to give a little bit of insight. How does that work? Why is a company that is a foreign company that is paying a bribe somewhere else, or at least in the mind of employees, paying a bribe somewhere else? Where's the U.S. fall into this broader holding accountable those firms or those employees' actions at that company?
Yeah, and I think, look, it's a great question. There's an overarching.
Thanks, Dan. Yeah. Thank you.
Eugene, it's a pleasure being on a panel with you. It's you ask very, very good questions, and you always are very sharply dressed as well. So it's always great. No, look, I think there's the overarching jurisdictional principles of nationality jurisdiction, which would be, if it's a U.S. company, U.S. individual, that there would be jurisdiction over that entity or that person. And then there's the territorial concept of jurisdiction, where some conduct occurs within the territory of the United States. And it's the latter one that is really triggered by what you're asking, and it's answered on a statute by statute basis. I think there's discretionary concerns always if the nexus to the U.S. is very limited. But if you look at, for example, the money laundering statute, even if it's just a transaction that goes through a correspondent bank in the U.S., the courts have held that that's sufficient. If you're talking about wire fraud, the courts have come out differently on different occasions, but for the most part, they're looking at the wire transfer in furtherance of the fraudulent scheme and whether or not that went through the U.S. The FCPA, and there's an entire chapter in the book on FCPA, and it's where Leo and I have spent a great deal of our time as prosecutors and now on the defense side. That's a much more complicated statute, and there are actually three separate provisions within the FCPA anti-bribery provisions that talk about jurisdiction, and a fourth that is layered on top of those three. So there is nationality jurisdiction. There's also territorial jurisdiction, but the territorial jurisdiction would apply, for example, if you are a foreign company that is traded on the New York Stock Exchange. But then if that's the case, you still have to use U.S. interstate commerce. So some use of an email or a financial transaction that occurs in the U.S. And if you're just a foreign company that is based abroad and doesn't trade on a U.S. exchange, one of your employees or agents has to physically be in the United States while some corrupt act is taken by them while they're in the U.S. And then it can be imputed to the company. And we've seen a number of FCPA cases based on that theory. But it's a complicated issue and question. And that's just from the legal standpoint. I think there's a whole separate question from a policy, a diplomatic standpoint of should we be deferring to a foreign authority or not? Should we be bringing this case or allowing the foreign jurisdiction to do it? So with that, I'll shut up and let Leo jump in.
Yeah, no, I totally agree with everything Dan said, and I think the one thing that I'm really happy about this book. But. That's right. You can see we've spent way too much time together over the years. But I think the one thing that the book does really well, and what really precipitated the writing of this book is people can research the law, they can research the policy. But what is a little bit of a black box for me starting to do this as a prosecutor was the practice of this. And for example, talking about this process of globalizing the investigation and prosecutions of corporate crime, it's really unclear. I don't think it's really well known like how all of this works. For example, the MLAT process, the process of informal cooperation between law enforcement agencies. The use of Patriot Act subpoenas by the DOJ, how the DOJ handles foreign data privacy laws, or coordinated resolutions, the anti-piling on policy. Like all of these things go into the practice of how the DOJ investigates a corporate criminal misconduct that may happen to involve other jurisdictions, and those other jurisdictions are also investigating. And so, Dan in particular has done, probably more than anyone in the country in terms of these very complex multi-jurisdictional resolutions and investigations and all the issues that come out of that. So Eugene, it is a great question from several angles, but I think what the book does is it pulls back the veil a little more on the practice of what happens in the context of these multi-jurisdictional investigations and prosecutions.
I think that's actually a great point, Leo, in that it's trying to cover not just what the law says on paper, but actually trying to illuminate how it works in actual practice. And I can say, sitting with my business school hat lens, actually just talking about this topic today with senior leaders from across many countries, many are actually quite surprised and actually, I'll say, quite intimidated when they actually hear about this kind of breadth of liability that they face, because I think they'll say naive view that I think many business leaders have is, well, of course I need to play with the rules of kind of the game in my jurisdiction. And you actually know what the kind of the unspoken rules about what works and what does not. And I think one of the things in our increasingly globalized world, we actually see is that the US actually places a significant amount of potential focus and scrutiny on companies that are operating in some different ways connected to the US jurisdiction. But actually, as other companies are also picking up similar practices, that this is actually this practice is kind of many jurisdictions looking at many other jurisdictions, making it much more complicated to operate effectively and safely in many environments.
Yeah.
One of the things that, yeah. Oh,
No,
please,
no, no.
Dan.
I was just going to say, and it's really the combination of all these things that I think is what leads us to where we are right now. Because it's as Leo, it's first of all what you described at the beginning, Eugene and Leo, in terms of the very broad standard of liability for corporations, respondeat superior, which really gives prosecutors a lot of discretion and really a lot of power. And then you combine that with very broad jurisdiction. And so their ability to rope in a lot of conduct and a lot of different companies, that makes it such that a corporation is oftentimes unwilling to go to trial because the downside risk is too great. And the potential collateral consequences of being indicted or being convicted at trial, both reputationally and just from a collateral consequences, debarment, losing business standpoint, is so great, which then leads you to what Leo just described of not really having a lot of case law in this area and really not having a handbook. And I was the same as Leo when I went to work for the law firm that I'm at now. I started there as an associate. There's no handbook on how to do an internal investigation. There's no handbook when I got to be a prosecutor of, here's how you do a government investigation. Here's how you do a multi-jurisdictional investigation. So that really was a driving force here for writing the book.
You should have taken my approach, which is I just learned from both of you, which is both very, very effective teachers. And I would say to all those listening, that gets then distilled in this book as a way of learning the approach as well. When it comes to other resolutions, because I think this is, given that firms are not going to trial, but we know that there are many cases, and Dan, you referred to these, the alternative and different ways of approaching the resolution. Maybe we could just discuss that for a few minutes, because this is something that even when we see cases described in the Wall Street Journal, it's very fuzzy about what they mean. People are not using these DPA, NPA, and all these terms, but that's the basis of really the most substantive area of corporate criminal prosecutions.
Yeah, and happy to kick it off. I think that is really the part that a lot of folks who practice in this area have experienced it. But again, there's some guidance from DOJ. It's oftentimes in the form of policies, as well as from the SEC in terms of how to resolve these types of cases, what factors should be considered. And so the SEC has a list of factors to be considered called the Seaboard factors. The DOJ has the principles of prosecution of business organizations. But how those all get applied, I think, is a much less transparent. It's not that it's not transparent in the sense that anyone's looking to hide the ball. It's just they can't be prescriptive because every case is different, every company is different, every circumstance is different. And so what happens across the table as prosecutors are sitting across the table from companies, what information the department wants to hear, that is much less known. And so again, I think it's the type of thing that at least until now, that you really could only learn it by participating in that. And what we really try to sort of walk folks through how this all works.
Yeah, and I think one of the things I find most fascinating about this area is that because, as Dan said before, corporations aren't going to trial. Usually, we're seeing that a little bit more these days recently. But the overwhelming majority of corporate matters are resolved through a negotiated vehicle or agreement with the Department of Justice. And it's interesting because, if you don't have that judicial check on prosecutors, then you need some other check. And I think what we've seen is that the DOJ has imposed its own sets of restraints and policies that require prosecutors to consider certain factors and to not request companies, for example, to waive the attorney-client privilege. And how do you give cooperation? And how do you provide how do you consider what the appropriate resolution ought to be, what the penalty ought to be? Like all of these functions that would typically, if you're in the individual context, happen in a court, and even up until the point of if there is an offer made by the line level people, there's a process you can appeal up to higher level folks at the DOJ to try to make your case that the offer is not just. And so all of this is somewhat mirroring what would happen in the courts, and it's just interesting that given that you don't have this judicial structure, the DOJ has put one in its place that somewhat mirrors it, and which is why I think that when, as the DAG recently came out with some changes to the DOJ's policies, at least in our world, everybody was paying with rapt attention to what she was saying, because these policies are really what govern how the DOJ is going to carry out its corporate enforcement program.
Okay, turning to the book, I'm going to ask an unfair question now, but why not? Since we want to go through a little bit of what's actually in the book, but I'm going to ask you, what's your favorite chapter? You can choose your own. So we did this collectively, but you could choose your own or one else.
You can't do it.
Which is your favorite chapter?
It's like choosing among your children, right?
Come on. We all know you can do that secretly.
I've been told that I was wrong when I did that. So,
yeah.
Leo, do you have a favorite chapter?
So God, it's like Christmas time, Eugene. I mean, look, I think so. I actually think that the chapter I found most interesting was it's chapter 2 on corporate intent, because this idea of how you ascribe a mental state to what is essentially an entity with no brain was really fascinating to me, and just how over the years the courts have evolved ways to try to mimic what the mental state of the corporation is, and not really successfully, again, using responding superior, just looking at the mental state of a single person to say that the corporation possessed a criminal mental state. I think, but looking at all the other different models and even, where courts have allowed prosecutors to go even more, a more lenient standard than responding superior, which is not, if you don't even need to have a single person with the required mental state. The courts are willing to allow prosecutors to add up knowledge to get to a mental state, something called the collective knowledge doctrine, and not something that's widely used by the DOJ, but certainly is a live doctrine that is still invoked here or there. And so I thought that just the way the law is evolving to try to accurately figure out what the mental state of a corporation was really interesting, and I think it's also fascinating to follow because I don't think it's over yet. Like, we keep hearing about what is the role of compliance in determining what the true mental state of a corporation is, and even if you don't have a compliance defense, I think the DOJ is inching towards that by making compliance so important as a factor in determining what the appropriate punishment ought to be to a corporation, if at all, punishment ought to be for a corporation that is engaged in misconduct. So that was my favorite chapter.
I think I'm going to cheat a little bit. I mean, I'll give an answer, but then I'll explain a broader answer. But I think corporate resolutions was probably my favorite, just because of the breadth of the topic, and because there's no case law on it. And so this really is, as I was saying before, something that you only learn by doing it until now. And so really having this roadmap for how this all plays out, the different types and forms of corporate resolutions, the various aspects. I mean, there's a lot of different axes that and levers that prosecutors can pull in terms of the form. Is it an NPA, DPA, plea, declination, the monetary amount, and what goes into the types of monetary sanctions, whether or not there's a compliance monitor, and what the compliance requirements are, and then where within the company is the resolution? Is it at the parent? Is it at the subsidiary? Is there one of each? And what the charge is? and then sort of walking through that whole process, to me is something that really hasn't been covered before. Now I'm going to cheat and say that I think for the same reason, the chapters on government investigations, internal investigations, multi-jurisdictional investigations, and monitorships are also very novel in that sense. Not something that you generally see covered from this perspective, at least. And so I think all of the chapters are obviously really important and cover a lot of very important ground. But those are the ones that I would focus on for that reason. Eugene?
Okay.
Yeah.
I'll give an area that I think is going to cut across 2-3 chapters, but so I guess I'm cheating in a way as well. But I think that in so much other areas, we think of criminal law, we know what happened. So let's just take like murder. There's a body. Like, and the question is like, who did it? And what were the circumstances in which that happened? But the crime happened. There's little doubt. What's so fascinating is you look at, internal investigations, government investigations, and then even the process about how the resolutions can then occur. The question is, did this rise to something that was criminal? And this is such a nuanced area that I don't think really can apply to a lot of other areas when we think of like criminal law, where oftentimes we're genuinely still trying to figure out, it's both the government and inside the company, was this an error? If we think of like cases like fraud, was this simply that the business fell apart because the environment changed in a way that was unexpected, but in a way that was not ill-intentioned, or maybe just very aggressive? Or is this someone that was trying to deceive or harm someone else? And that's genuinely not always obvious in many instances. And actually, in fact, in some of the areas we can think of like bribery, people might actually have what I call, at least on one hand, a positive thing that they were trying to achieve. They were trying to help their company, and they believed paying that bribe to get something done actually was helping their colleagues, was helping the company. But that's actually not right. That's actually criminal. And so actually trying to figure out how we investigate that both internally and then from the government side, and then how the resolution occurs, because to the extent there are not many areas where if you disclose that what you did, you do it transparently, you actually cooperate with the government, and then you design a program to say that you won't do it again, that could actually lead to ultimately something like a declination, effectively make that crime essentially dissipate or go away. Again, typically, if you have a body, you can't disclose that, apologize, explain why you won't do that again, and then it actually changes what the crime itself was and what that resolution will actually look like. And because of that subtlety and all that complexity, and I think what we're trying to illustrate here in the book of how this actually works in practice, makes it such a subtle, fascinating, I think actually really intellectually rich area to figure. And as Leo's pointing out, it's also constantly changing. Our book was published on the day that I'll say already have probably 2 more pages that we need to add to the book, because it actually is continuing to evolve as well.
Yeah, and I think that I mean, it's a great point, Eugene, and if I do say again, you're making excellent points, Eugene. No, the truth is, and that ties into, I think, the recent guidance that Leo referred to from coming out of the DOJ. And I think there have been some fair criticisms of some of the guidance over the past year that it doesn't recognize the difference between individuals and corporations. And so, what you're referring to is, Eugene, why would a corporation have that treatment where they voluntarily self-disclose, they cooperate, they remediate, and then they get a much more lenient outcome and potentially a declination? And I think that boils back down to the distinction with a corporation. You can have a corporation of 50,000 employees, and one employee engages in a very clear violation of law, and may in fact be doing it to benefit the company. But the company is a good company at its core, has put in place a strong compliance program. Once they identified the conduct, caught it, terminated the employee, cleaned it up, strengthened their controls, walked it into DOJ. I mean, it's hard to say that that's a company that would be deserving of some sort of sanction. And so again, I think the the new guidance that's come out from the DOJ, I think the concern is that that doesn't always recognize good corporate behavior, and maybe looking at certain cues like recidivism and whether the company has a prior history of misconduct and overweighting that. And so that's, I think, a really important debate and a really important issue, and one that, hopefully the book also sheds a lot of light on.
The element of discretion here, I think that's being highlighted. It's just what makes it so fascinating, the element of disclosure and how these subsequent memos that come out are subtly changing that calculus as a company seeking to potentially disclose or choose not to disclose, how much to invest up front into their compliance program, into the investigation, and all of these subtle decisions that are actually being made that have just such tremendous ramifications for, as you point out, a company of 50 or 100,000 people, literally the lives of tens of thousands of people, the vast majority of which potentially have no idea and actually no connection whatsoever to the potential allegations that are being made.
Yeah, no, it's a great point, and at the end of the day, because as Dan said before, because of the low legal standard, the discretion really just lies with the trial team. I mean, they just have a tremendous amount of discretion to select what the appropriate charges ought to be, what the form of the resolution should be, the amount of the penalty, the term of the agreement, the remediations, whether there should be a monitorship. I mean, all these things. While there's lots of policies on this, the policies don't dictate outcomes. And I mean, look, this is really no different than other areas where a prosecutor has discretion over, how to charge an individual. But I think in the individual context, though, you just have so many more resolutions. So if someone, so many more data points. And so if somebody goes in and robs a bank, it's bank robbery, right? But it's not so, and then the sentencing guidelines are clear. The things are much more clear in the corporate context. This distinction between whether a resolution is an NPA or a DPA or a guilty plea. I mean, these are discussions that prosecutors have inside the office debating these issues every day, and they're not easy issues, and they're left to the discretion of the prosecutors. And so a lot of the questions that we get in class, in our Harvard Law School class, is like, how does this impact something, or what does this mean? And what we always return to is that, well, it depends, because these rules and policies require prosecutors to actually implement them. And so, some people have criticized how much discretion, especially courts who don't have a large role in this process, how much discretion prosecutors actually have over corporate criminal resolutions. And again, I think it's a fascinating issue that we've debated in class and are debating right now in our class at Harvard. And I think it will continue to be a big issue.
Agreed.
Well, there are other areas, and I know we wanted to give a little bit of preview over the book. Leo, other areas that we should highlight around the book as a setup that readers ought to know.
I mean, there's a few. They're not like the I guess the most important parts of the practice. But as Dan said, what we tried to do was not to just consolidate what others had written and was already out there. What we tried to do was really to ask ourselves if we wanted to have a handbook, right, or a case book, a teaching tool or a learning tool that would help us understand this area of practice. What would that look like? And so there's, for example, 2 chapters, one on corporate constitutional rights. That is in the criminal context. That, as far as I can tell, there have been some law review articles written about it, but not this sort of comprehensive treatment of what constitutional rights do corporations have. And it's again, as with many parts of the book, it's very interesting. Corporations do not have a Fifth Amendment right against self-incrimination, but they do have a Fourth Amendment right to be free from unreasonable searches and seizures. There's a chapter on corporate criminal trials, which again, no one really talks about because they don't really happen very often. Yet the process of putting a corporation on trial, how that works, how evidentiary issues and issues of representation. Can corporations qualify for if they're indigent, do they qualify for court-appointed counsel? The answer is no. But these are sort of all questions that we've always wondered about. And so if somebody were looking to take a corporation to trial, it goes beyond just the nuts and bolts, but also to advocacy. Do you need to have a corporate representative there? How do you humanize the corporation? By looking at past corporate trials. So, and then I think the one part we haven't mentioned is sort of part 2 of the book, which is where we do deep dives into individual federal statutes that are most commonly used to charge corporations, and FCPA sanctions, and your sort of usual suspects, money laundering and bank secrecy act, but also other crimes as well that may not be as well known, such as like wildlife crimes. And there's a chapter in there on virtual currency that we wrote that I think it actually is really timely because of a lot of what's happening in the cryptocurrency world right now. So I think there's a lot of fodder there for folks to be able to craft classes around these, not only the practice of corporate criminal liability, but also specific statutes that are used to prosecute corporations as well.
Has there ever been a case, I think I asked this once years ago to you, but a court-appointed lawyer, a company said they couldn't pay and they would have a lawyer. That's never happened, has it?
So one company did petition for yes, for a court-appointed lawyer, and so the the district court I don't remember what district court it was, but the Ninth Circuit affirmed that corporations are not persons under the Criminal Justice Act, which allows appointment of counsel, and so they did not get appointment of counsel.
Okay,
so
that's a good.
But they do have a Sixth Amendment right to counsel. They just don't have the right to free counsel. So, oops. Oh, there goes Eugene. So anyway, I don't know, Dan, if you have any thoughts about that, like the other parts of the book as well.
Yeah, no, again, I think what we tried to do is cover the types of substantive crimes and statutes that are going to have the greatest impact and be most likely to apply to corporations. So, there's obviously any number of white collar crimes, but these are the ones that we think are most applicable to corporate investigations and prosecutions. And just to return to a point that I think Leo made earlier, and I think it's an important one, and he was talking about the criticism of the immense discretion by prosecutors in these types of cases, and there's no question that they have immense discretion. And I think that the flip side of that argument is, depending on the type of case and crime, there are specialized units that are set up within the department that deal with them. And so, for example, the antitrust division deals with antitrust cases, not surprisingly. The FCPA unit handles all FCPA matters. And so because of that, you have essentially a body of precedent within those units, and they try to, obviously they always come back to the same retort that no one case is the same, but at least they try to stay within the bounds of similar cases should be treated similarly. And defense counsel at least have a lot of policy arguments and arguments based on this precedent. And I think the issue where you do end up in front of a judge is really if you're in front of a judge in one district in one state, and you have the exact same case as another one in front of a different judge, they're not as tied to the precedent, and they will do what they think is right in that particular case. But you could end up with wildly disparate resolutions. And so in some ways, and again, I'm not saying this is the right way to look at it, but I think the counter to the point about too much discretion is the counter that with that discretion oftentimes can come and depending on the section within the department does come with at least sticking to that precedent in a way that you might not if you were in front of different judges.
Interesting point, Dan. I mean, it also strikes me as in many cases, detection is much harder in this context, again, compared to like what we call a street crime. And so to the extent that we ultimately know what the department would ultimately see, we'll have massive selection. It's the tip of the iceberg between all conduct. In fact, companies only see a tip of the iceberg potentially associated with what may happen. And if that discretion was not actually provided, you would actually have a system in which simply the detection itself would primarily determine outcome, more so than the other aspects, which are around substance and around the other aspects that are taken into account in terms of how firms are ultimately sanctioned.
Yeah, and look, detection, one of the issues that we talk about in the government investigations chapter is detection and how cases are getting generated. And again, I think that is something that's evolved over time as well. And it's something where, for example, in FCPA cases, I think the overwhelming majority back when I started in the FCPA unit in 2010, a lot of the cases had been coming in through voluntary disclosures. And then you saw the department start to try to generate cases more proactively and do tougher cases. And again, that is why it's really important that the department incentivizes cooperation from companies, because it's really hard to gather evidence from overseas. And that's, again, something we cover in the multi-jurisdictional investigations chapter, that it's just really difficult and sometimes impossible to gather that evidence formally. And so if you have cooperation either from the company or through relationships with authorities in the foreign country, it can make things a heck of a lot easier, which then leads to a more expedited investigation and resolution.
Yeah, just really quickly, Dan already touched upon this, but one of the big debates that we have in class as well, or discussions, is the voluntary self-disclosures is in some sense like the golden goose, and companies don't have to come in. If companies don't come in, there's a high probability that misconduct just is never going to get disclosed or discovered by any law enforcement agency. And so, how do you encourage companies to come in? And that's by giving them a tangible benefit, transparency, predictability in terms of what they will get if they come in and voluntarily disclose. And that's why this discussion about, why are corporations being treated so leniently by getting a non-prosecution agreement or a deferred prosecution agreement is so interesting, because the discussion is the analysis is so much more nuanced than that, right? It's not just look at what the corporation did and what the appropriate punishment should be. There's all this other corporate conduct that should be considered, I believe, in determining what the right resolution ought to be. Like Dan said, cooperation, remediation, self-disclosure, all these things that may merit something less than a guilty plea, even though the conduct was serious. So I think this balancing, it doesn't really exist in the individual contexts, not like this at least. And so this whole and all these sort of moving pieces, these levers, as Dan called them, are just very interesting and certainly a fruitful area for discussion in class.
Yeah, and again, and just to come back to the new guidance that's come out from the DOJ, again, I think one of the concerns is that although the Deputy Attorney General, that essentially the chief operating officer of the department, created a disclosure program, a voluntary disclosure program, whereby all components would have to come up with their own voluntary disclosure policy. The incentives are not that great. And so as Leo's saying, the reason you see declinations and NPAs is because the department realizes that it's really beneficial to have a company walk a case in. It's beneficial because the department may not have found it otherwise. It's beneficial because the statute of limitations is oftentimes a real significant issue for the department. And so if a company walks it in sooner than the department would have found it, they're able to conduct and complete their investigation before the statute of limitations runs. And so you see the FCPA policy, the voluntary disclosure policy, the National Security Division, the Antitrust Division have all put out policies where they essentially provide leniency, either a declination, a non-prosecution agreement for a company that voluntarily self-discloses, fully cooperates, and fully remediates. Even with that, there are a number of reasons why, and I'm sure Leo is in the same boat that I am, that I would seriously consider advising a company to not voluntarily disclose if they find misconduct, because even if you end up with a declination, you're still looking at a years-long investigation. You're still potentially looking at an SEC or regulatory action. A foreign jurisdiction is almost always these days triggered as well, and may have a foreign resolution. And then if you're a publicly traded company, you're very likely to have shareholder follow-on suits. And so there are any number of reasons why it just may be worth it for a company to, rather than voluntarily self-disclose, to instead clean up the misconduct, fully remediate, enhance the compliance program, and be ready to cooperate if the department comes knocking, but not just walk it into the department and have all of those follow-on consequences. And what the Deputy Attorney General has done now is, putting aside antitrust, FCPA, and National Security Division, all of the other components need to put out a policy that says that if you voluntarily self-disclose, cooperate, and remediate, there will be a presumption against a guilty plea, absent aggravating circumstances, which, at least when I was at the department, most of the time there wouldn't be a guilty plea unless there were aggravating circumstances in the first place. And so it's not a huge carrot. And the stick is just so great that if you walk it in, that there are all of these negative consequences that I think a lot of companies are going to have to think twice before voluntarily disclosing.
Yeah.
That was the most interesting topic and very timely. Thanks, Dan. I mean, do we have any? I don't know if we have officially any questions. As you see, I think us three we could discuss. We could discuss this all day. Well, we do.
Thank you so much. Yeah, so if anyone does have any questions, please feel free to type it in the chat and I can read it out loud. And we do have some. So why don't we get started? So first off, do you think more foreign countries will join the DOJ in corporate criminal resolutions in the future? And how will that impact the practice in this area?
Yeah, so I think the answer is definitely yes. And you see that almost every year there's a new country that coordinates and cooperates with the department. And I think that will change and impact the practice in this area. And it can impact it in several ways. One is it's somewhat of a mixed bag, and I think in the department's view, definitely a net positive, but it's not as though cooperating and coordinating with foreign jurisdictions is all upside. I think the upside is definitely easier access to evidence, which is critical. Getting foreign countries engaged is really the only way to combat multi-jurisdictional crimes, and in particular corruption. The flip side of that is anytime you're trying to coordinate with a foreign jurisdiction, there's going to be a number of legal and practical challenges. And you saw that play out, for example, in one of the LIBOR cases where a conviction was reversed and thrown out, and the indictment dismissed in a case where one of the cooperators of the government was exposed to testimony by the defendant that was compelled in the UK, because in the UK they can compel testimony. And so the different legal systems, I think, are going to have a real impact on the way that the DOJ conducts these investigations. But I think, again, as I said, ultimately they would take on that risk and try to address it in order to get the value of having more authorities pursuing these types of crimes and providing evidence.
And just, I agree with all that. I would just quickly add too that the other change is going to be the more countries that get involved in these resolutions. I think Dan can speak from experience. I can somewhat as well. Is that, remember, these are all independent sovereigns with their own perhaps separate agendas and separate interests, and trying to get everybody to do a coordinated resolution where everybody agrees on the terms and the dollar amounts and things of that nature it's already complicated, and as more countries become involved, I think it's going to get more complicated.
Great. Thank you. Next question is, why is corporate compliance such an important factor for the DOJ?
Eugene, I don't know if you want to take that on. I can certainly speak to it from the department
standpoint. Why don't you speak from the department standpoint? At least I'll say why firms are spending a lot of time in this area.
And so I think from the department standpoint, it's relevant both in terms of what the resolution should look like as well as what they're trying to achieve. And so from what the resolution should look like, the department's policies actually have several places where they refer to compliance. So they're looking at the company's compliance program at the time of the misconduct to try to judge how culpable the company is in the misconduct, whether they should exercise their significant discretion and power to impose a sanction on a company where maybe it was just one individual or 5 individuals out of tens of thousands. But if the company didn't have an effective compliance program at the time, that would weigh in favor of a harsher resolution. And what the company has done to improve its compliance program is also a factor that addresses that issue, and also whether or not the company is in need of a monitor as part of the resolution. But also, I think at the end of the day, the department is seeking to achieve deterrence. And the best way to achieve deterrence is through enhanced and effective compliance programs, because at the end of the day, the department can only prosecute crimes after they happen. It's the companies who are the ones that are on the front lines and able to actually stop it from happening or shorten it and make sure that it's not as egregious as it otherwise would be. So I think that's the department's perspective. But Eugene, why don't you hit it from the companies?
Yeah, but I like how you how that was framed. In that, I mean, the ideal world, luckily, I think most companies that are operating in equilibrium don't want misconduct to occur. We want to operate a successful and sustainable business. So ideally speaking, every company runs into issues, and these are not issues that are civil or criminal issues, but they're challenges and part of the business challenges. Ideally, you have those people have their manager actually say that that's not appropriate, that's not how we do things, it violates process, and you immediately resolve it, literally on the spot. Sometimes that doesn't work because of pressures that managers face or other business considerations, and then this rises to the level of going to the hotline or formalized and centralized compliance processes, where if they're well designed, then that gets remediated at that point before it becomes something that would, frankly, even if it was disclosed to someone at the Department of Justice or the SEC, would be of interest, because it's still, in the scheme of things, quite minor because it was caught earlier. And I think of actually DOJ, that's kind of the last ring. When something's actually reaching that, it means people didn't have the psychological safety and or operating environment where they could immediately get constructive feedback to stop it initially. There was some failure internally in the company that they weren't able to either identify it or correct it. And so it's falling into where, from the deterrent standpoint, and actually the firm rightfully ought to be potentially punished in those circumstances, because there was wrongdoing, and they need the encouragement to actually have that investment to hopefully prevent that recidivism from arising again, by putting in better processes, by actually placing effort, so it's not simply a check the box, but it's actually something that is actually encouraging the kind of high integrity conduct that I think we all, as like individuals in a well operating society, would like to have.
Wonderful. Thank you so much. I do not see any more questions at the moment, so I will turn it back to our author team for any final remarks. Are we all good? Wonderful.
We enjoyed writing the book, so hopefully people that can enjoy reading it.
Wonderful. Thank you so much for your presentation today, and thank you all for attending. The webinar has now ended. I hope you all have a great rest of your day. Thank you.
Thanks so much.
Thank you. Bye-bye.